Matt, you've published a report on the demise of judicial deference, which you point to being substantial and fast developing. What does this mean?
Yeah, Roger, thanks. So for 40 years, federal law in the United States has been shaped not just by the laws that Congress passes, but also by how those laws have been interpreted by federal agencies that administer the laws, the EPA, the FCC, the SEC, the FDA. Those agencies have determined how far those laws have reached, and they've done so because of a judicial doctrine known as the Chevron Doctrine that gives the agencies deference anytime they read those laws. That doctrine has had a substantial impact on regulated businesses and industries. For example, in the broadband space that I focus on, the FCC is interpreting a 1934 law that didn't address broadband specifically. That's the most important communications product today. But the FCC has interpreted that law to say it should extend to broadband, and we should be able to regulate it. And courts have deferred to that. That deference has a substantial impact on the industry.
And where does demise of deference come in?
Yeah, so that's the big development here. So even though this case in 1984 established this doctrine and it's been applied hundreds of times, in recent years it's received substantial criticism to the point that we now have substantial doubt that that doctrine is going to survive. There have been two developments in the law that are really driving it. One, in 2022, the Supreme Court announced what's known as the major questions doctrine, that said that agencies no longer get that deference on anything that qualifies as major. And two, the court has now taken up two cases that it's going to decide in May or June that ask whether that deference should apply even in non-major questions. We see substantial risk that the court will, if not completely end Chevron deference, extremely narrow it in those decisions that we expect in the coming months.
Thank you, Matt.